Thank you very much for the invitation to attend this important meeting. And in particular, thanks for the vision and leadership of His Holiness Pope Francis in this and in other important areas involving human and environmental rights. As all of the speakers so far have said, the criminal activity of trafficking in all its manifestations is an assault on human dignity and the modern equivalent of human slavery. It is our duty as judges and prosecutors, within the limits of our roles, to do all in our power to eradicate this terrible crime against those who are usually the most vulnerable in our societies. The first important role for judges and prosecutors is in the criminal field. We can play an active role in addressing human trafficking by ensuring that our national laws to combat trafficking are properly applied. Even where there are no specific laws against trafficking that can be applied in the particular case, we should be alert to and use national laws that prohibit criminal actions commonly associated with the activity of trafficking. These could include, for example, laws criminalising assault, money laundering, kidnapping and extortion. But where possible, I think prosecution should be brought under the specific trafficking provisions. Even if a prosecution is ultimately unsuccessful, this gives the crime its proper name, raises awareness and underlines the state's determination to fight trafficking. Judges should also be vigilant in attempting to identify instances of trafficking. It might be that we come to suspect that a person appearing before us is an actual fact a trafficker. They could, for example, appear before us for labour law violations. In that case, if we have our suspicions, it seems to me that we should report the matter to the relevant authorities so that it can be properly investigated. Prosecutors will have even more scope to identify traffickers and ensure they are charged appropriately, and as a number have said already, follow the money. Judges should also ensure that appropriate sentences for convicted trafficking offenders are imposed. The fact that offences have been committed in the course of trafficking a human being has to be a seriously aggravating factor for sentencing purposes. Other aggravating factors may well include the use of weapons, the targeting of vulnerable victims, the use of narcotics to control the victim, and the fact that the offence was motivated by financial or material gain. Where possible, reparation to the victims and confiscation of profits should be ordered. Moreover, we should be wary of granting bail to alleged traffickers, given the very high risk of flight. We must, however, be cognizant of the fact that trafficking victims can become the traffickers of future victims. This phenomenon provides challenging sentencing issues because of the likely duress involved in turning a victim into a trafficker. And the issue will always be the extent to which this can or should be treated as a mitigating factor in sentencing. And of course, there are possibly even issues as to criminal liability, depending upon whether or not your jurisdiction treats duress as an offence, a defence. There are, however, difficult issues of proof if the alleged duress consists of threats to family in another jurisdiction. The next important role for judges and prosecutors is in the protection of victims. An essential factor in ensuring the protection of victims of trafficking is that they should not be detained or prosecuted for offences directly associated with their being trafficked, including those related to their illegal entry into a country. In countries where prostitution is illegal, judges should attempt to ascertain whether the person charged has voluntarily entered into prostitution, assuming we can say prostitution is ever voluntary, or been forced into it. It is difficult to see how prosecution of a coerced victim can ever be justified, but at the least, if judges are obliged by their laws to convict, any penalties should concentrate on rehabilitation rather than punishment. We also must not forget other avenues of redress for victims, such as the protections under labour laws, as well as other civil remedies, such as damages or account of profits. To the extent appropriate, victims should be given assistance in accessing these remedies through, for example, referral to a lawyer specialising in such cases. Steps should also be taken by the courts to protect victims in situations where alleged trafficking offenders are on trial. For instance, the use of testimony by video link can protect the witness from direct confrontation with and intimidation by the accused. Moreover, additional measures such as imaging and/or voice-altering devices can protect the physical security of the trafficking victim. Other steps can be taken to assist in lessening the trauma of giving evidence through the ability to have a support person with them while they're giving evidence, the pre-recording of evidence, different questioning methods, and prior court visits to make the process less intimidating. We must also be vigilant in our courtrooms to identify anyone who might be a victim of trafficking. Such people could come to court for a variety of reasons, for instance, immigration issues, petty crimes, prostitution in countries where that is illegal, or as witnesses perhaps in assault or domestic violence cases. If we do have any suspicions, then it has to be our duty to ask further questions or to ask someone else who is an expert in trafficking matters, such as a social worker, to do so. It might be, for example, that you can see someone in court obviously controlling the victim. You could then perhaps clear the court to make further inquiries and make sure that the person you suspect of intimidating the victim is excluded from any subsequent proceedings, and that's even if they pose as a supposedly supporting partner. Adjourning the case to facilitate further investigation by the proper authorities may be an option. We also need to think of creative ways that victims might be protected. A judge could examine whether the victim could conceivably fall within the scope of the definition of refugee provided in the 1951 Convention relating to the status of refugees in order to benefit from the obligation of non-refoulement encompassed within the Convention. A judge could also consider other international human rights obligations which might allow victims to stay in the country they have been trafficked to and not be sent back to their home country if they don't want to go. If we are legally obliged to send victims back to their home countries, then at least we can inquire whether they will have access to proper services from state or non-governmental agencies when they are sent back, including counselling and medical services, and more importantly, that they will be protected from being trafficked again. If possible, we could refuse to send a person back without being assured services are available. In addition, there might need to be services to the family and to the community to allow reintegration and, of course, protection against re-trafficking. Finally, there is a need for education and cooperation. We must educate ourselves and others, including the public, about the crime of human trafficking. Of course, in order for the judiciary and prosecutors to take such measures, it's vital that awareness about the different facets of trafficking exists. The fundamental need for judicial and prosecutor education in this field can't be overemphasised. The focus of such training should be on the applicable legal framework surrounding trafficking and related offences, both internationally and domestically, and on the roles and responsibilities of the judiciary and prosecutors in this regard. The International Association of Women Judges, as we call it the IAWJ, has already played a major role in this education, and I understand the President-elect of the organisation, Vanessa Ruiz, will talk about these initiatives tomorrow. In most of our countries, there will be some government action to try to combat trafficking, and this is because political awareness of the issue has grown over recent years. To the extent appropriate in our particular jurisdictions, I think that judges and prosecutors should have a role in contributing to the content of government action plans. We have a particular perspective to add because of our role in the criminal justice system. Given the multi-jurisdictional nature of much trafficking, another requirement is international cooperation. Organisations of judges such as the IAWJ could have a real role to play in this regard, and the IAWJ is committed to combating this crime. Perhaps the IAWJ could consider collecting cases and best practices from its members and have that resource available for those working in the field. it could also, and it will, continue to build networks with other organisations dedicating to combating trafficking. Cross-border cooperation is a key aspect in a globalised crime such as this, and the IAWJ provides a network of judges who could be called on if cross-border cooperation was required in particular cases. Just turning very briefly to the situation in New Zealand, no country is immune from the problems associated with human trafficking. New Zealand is a small country and geographically isolated. As such, it is difficult to enter except through official channels, and we have robust border controls. Despite this, one estimate is that there are currently some 600 slaves in New Zealand. New Zealand has dedicated trafficking legislation, and it's in place since New Zealand joined the Trafficking Protocol. There have, however, only been 2 prosecutions under that legislation, one successful and one unsuccessful. The successful prosecution was in the horticultural sector. Victims were brought in from Fiji with promises of lucrative work. Instead, they were enslaved with very harsh working conditions and appalling living standards. While the prosecution was successful, unfortunately, the profits had disappeared back to Fiji, so reparation was limited. It is worth mentioning specifically the fishing industry in New Zealand. Slavery on foreign-owned fishing ships, and some say also New Zealand-owned ships, came to light when sailors jumped ship and told tales of coercion and suffering. In theory, the sailors should have been protected because they had the protection, at least on a voluntary basis, of New Zealand labour laws, but that did not occur. The eventual government response was to require all ships operating in New Zealand to be New Zealand flagged. And they were also requiring the New Zealand fisheries observers, which were on the ships primarily to look for quota violations, also to report on working conditions. It remains to be seen whether such measures are going to be successful. New Zealand has had an action plan on trafficking. It's had that since 2009. The whole of government response to human trafficking and does focus on prevention. An update on the plan was supposed to have been completed last year, but this is now due next year, and this shows the complexity of issues that are involved. As so many fundamental human rights are breached through the crime of human trafficking, it is imperative that we as a group of international women judges and prosecutors all remain committed to combating this egregious crime. This requires a willingness to educate ourselves, to cooperate with each other, and to ensure that we make use of our national legal frameworks, not only to ensure the denunciation of all activities associated with trafficking, but also to ensure that all victims are adequately protected. Every one of us can play an important role in the fight against trafficking, and to the extent our roles allow, it is our duty to humanity to do so. Thank you.